I have presided over thousands of family disputes in 40 years on this bench, siblings over inheritances, spouses over property, parents over grandchildren. I have watched families fracture in real time, right in front of me, over amounts of money that would not cover a week of groceries. And I have learned slowly, across decades of watching, that the money is almost never what the case is actually about. The money is the thing that made the problem impossible to ignore any longer. The money is the point at which someone finally ran out of ways to absorb the difficulty quietly and had to bring it somewhere. But I have never, in 4 decades, across thousands of cases in all of those rooms, stood up from my bench during a hearing. I stood up on February 9th. I want to tell you exactly what happened and exactly why, because this story deserves to be told carefully. It is not a story about a mother suing her son. That is the filing. The filing is almost beside the point. This is a story about what happens when someone finally says out loud the thing that has been true for a very long time, and the person it is said to has nowhere left to look except directly at who they have allowed themselves to become. The case was called at 10:15 in the morning. I had already handled 4 cases before it. A parking dispute between neighbors who had clearly been fighting about something else for years and were using the parking dispute as a proxy. A landlord-tenant disagreement that resolved itself before I had to rule. 2 small claims matters that were straightforward and quick. The morning had been moving efficiently, the kind of morning you get through cleanly and go home from without carrying anything new. Then my clerk called the name. Frances Holloway, plaintiff, versus Kevin Holloway, defendant. I looked up. The woman who walked to the plaintiff's table was 71 years old. She was small and composed, with white hair cut short and a posture that carried 40 years of knowing how to hold herself in a room where she was trying not to be a burden. She wore a dark green blouse and dark slacks and shoes that were chosen for practicality, and she carried a small purse that she set on the table in front of her and did not open. She sat down. She folded her hands. She looked at the front of the room and she waited. The man who walked to the defendant's table was her son. Kevin Holloway was 44 years old. He was tall, thick through the chest, with his mother's dark eyes and a jaw set in the way of someone who has decided how the morning is going to go and intends to get through it as efficiently as possible. He wore jeans and a canvas work jacket, and he sat down with the contained impatience of a man who resents being somewhere and has stopped trying to conceal that he resents it. He did not look at his mother when he sat down. She did not look at him either. I have been reading rooms for 40 years. The space between Frances Holloway and Kevin Holloway was not the neutral space between strangers. It was charged and specific, the space between 2 people who know each other completely and are using all of that knowledge to avoid any contact. It is a particular kind of distance that only exists between people who were once very close and are now somewhere else entirely, and it is one of the saddest things I see in this room. I called the case and asked Frances to explain what had brought her to my courtroom. She unfolded her hands. She looked at me with dark eyes that were steady and tired in equal measure. She said that she was here because her son owed her $200 and that she had asked him for it 7 times over the course of 4 months, and that each time he had told her he would take care of it and that he had not taken care of it and that she did not know what else to do. I asked her to tell me where the $200 came from. She said, "I lent it to him in October. He called me and said he was short on rent. I did not have a great deal to spare, but I had that, so I sent it." I asked how she had sent it. She said, "I drove it to him. He lives 40 minutes away. I drove there and I handed him the cash, and he said, 'Thank you, Ma. I'll pay you back by the end of the month.'" "The end of which month?" I asked. "October," she said. "Last October, 4 months ago." I asked if she had a record of the loan. She said no. She said she had not thought she needed one. He was her son. She said it simply without bitterness, the way you state a fact that you have had to make peace with and have not entirely made peace with yet. I looked at Kevin Holloway. I asked him if he disputed that his mother had lent him $200 in October. He shifted in his chair. He said no, he didn't dispute it. I asked if he disputed that he had told her he would pay it back by the end of October. He said he'd been meaning to. He said things had been tight. He said he was going to pay her back. He just hadn't gotten around to it yet. "Hadn't gotten around to it," I said, "in 4 months. He shrugged. He said it wasn't a huge amount of money. The courtroom was quiet. Frances Holloway was looking at her hands. I asked Kevin a question. I asked him what he did for work. He said he was in construction, residential mostly. He said work had been slow in the winter but was picking up. I asked if he had been employed continuously over the past 4 months. He said mostly, yes. I asked if he owned a vehicle. He said yes. I asked if he had a smartphone. He said yes. I looked at him for a moment. Then I said, so in 4 months of being employed with a vehicle and a phone and a roof over your head, rent paid, presumably, since your mother helped you with that in October, you have not found a way to return $200 to the woman who drove 40 minutes to hand it to you in cash because you called her and said you needed it. He said he was going to pay her back. I said, that is not what I asked you. He was quiet. I turned back to Frances. I told her I had a few more questions if she was willing. She said, of course. I asked her to tell me a little about herself, not the case, about her life. She looked at me with a slight surprise, the same surprise I had seen in Evelyn Marsh's eyes, in Warren Briggs's eyes, in the eyes of people who come to this room expecting process and find instead that someone wants to know who they are. Then she nodded and she began. She had worked for 33 years as a school secretary, elementary school, the same building for all 33 years. She knew the name of every teacher who had ever worked there, she said, and the names of most of their children. She had been the person parents called when they were confused about a form, the person new teachers came to when they did not know how something worked, the person who kept the whole operation running in the background while other people stood in front of classrooms and got the credit for it. She had loved it. She said that plainly. She had loved it without qualification, the way people love work that fits the shape of who they are. She had retired 6 years ago when her knees made the stairs difficult. She had cried in the parking lot on the last day and hoped no one saw her. She did not think anyone had. Her husband, Gerald, had died 11 years ago. Stroke, sudden, a Thursday afternoon when he had been in the garden. He was 63 years old. They had been married 38 years. She had sold his tools 2 years after he died because she could not keep looking at them in the garage, and she had regretted it almost immediately. And that was the kind of regret you simply carried, she said, because there was nothing else to do with it. She had raised 2 children. Kevin, the younger, and his older sister Patrice, who lived in Phoenix now and called every Sunday without fail. Frances said this with a small emphasis on without fail that was not an accusation, but was in the room nonetheless. She lived on Social Security and the school district pension. She owned the house. She and Gerald had bought it in 1987 and paid it off together, the last payment in 2009, and she remembered that day clearly because Gerald had taken her to dinner to celebrate and ordered a bottle of wine they could not really afford and said it tasted like 30 years of showing up. She drove a 2009 Civic she maintained with care because she could not replace it. Her savings account, she said with no drama at all, was modest. She had what she needed. She was not complaining. $200, she said, was not nothing to her. She wanted me to understand that without feeling sorry for her. She was precise about this distinction. She was not here for sympathy. She was here because she had lent money she could feel the absence of to her son, who called when he needed it and went quiet when she asked for it back. And after 4 months of trying, she did not know what else to do. She looked down at her hands. She said, I know how this looks, a mother suing her own son. I know that. I thought about it for a long time before I filed, but I didn't have anywhere else to go. I have heard a great many things from this bench across 40 years. I have heard confessions and accusations and grief and rage and every variation of human desperation that a person can carry into a public room. But something about the way Frances Holloway said, I didn't have anywhere else to go, landed in that courtroom like a stone dropped into still water. And I watched the silence spread outward through the room, and I watched Kevin Holloway's jaw tighten, and I watched him look at the table in front of him and not look up. I let the silence sit for a moment, long enough to be felt. Then I turned to Kevin. I said, your mother just told this court that she had nowhere else to go. I want to give you an opportunity to respond to that, not to the legal question, into that. What happened next is the reason I am telling you this story. It is the reason I stood up. Kevin Holloway looked up from the table. He looked at me briefly. And then, for the first time since he had walked into that courtroom, he looked at his mother. He looked at her for a long moment. I watched him looking at her, and I watched her sit very still under that look, her hands folded, her face composed in the way of someone who has been bracing for something for a long time. Then he said, she always does this. Frances Holloway's folded hands tightened slightly, just slightly. If you were not watching for it, you would not have seen it. I said, I'm sorry? He said, she always makes everything into a bigger deal than it is. It's $200. I said I'd pay her back. She didn't have to come here and make it into a whole, he gestured vaguely, a whole situation. I said, a whole situation. He said, "She does this. She makes herself into the victim. She's always done this. Every time I don't do something exactly when she wants it done, exactly on her schedule, she acts like I've abandoned her. I'm her son. I'm not going anywhere. She's acting like I committed a crime. It's $200, Your Honor. I told her I'd pay her back." The courtroom was completely still. I looked at Frances Holloway. She was looking at her son with an expression I will carry with me for a long time. Not anger, not surprise. And that absence of surprise was its own kind of answer, its own testimony. What was in her face was something I recognized as recognition, the expression of a person hearing something said, plainly and out loud, that they have been hearing in quieter forms, in small daily ways, for longer than they care to count. She did not say anything. I looked back at Kevin. He had turned back to the table. He had the settled expression of a man who has made a reasonable point and is waiting for the room to confirm that it was reasonable. The room was not going to confirm that. I pushed my chair back. I stood up. I do not stand up during hearings. In 40 years, I have done it perhaps 5 times, each time in a moment that required the full physical weight of the bench to say what words alone were not sufficient to say. I stood up on February 9th because what I was about to say to Kevin Holloway required him to understand before I said a single word of it that this was not a routine correction. This was something different. He looked up at me. The settled expression shifted. He was paying attention now in a way he had not been a moment before. I said, "Mr. Holloway, I want you to look at your mother." He didn't move immediately. I said it again quietly and completely clearly. "Look at your mother, Mr. Holloway." He looked. I said, "That woman drove 40 minutes in October to hand you cash because you called her and said you needed it. She did not ask you what it was for. She did not ask when you would pay her back beyond the date you offered yourself. She drove there, and she handed it to you, and she drove home. And when 4 months passed and the calls went unreturned, she did not call your sister. She did not call a lawyer. She drove herself here to a courthouse and filed a claim for $200 because she, as she just told this court, had nowhere else to go. I let that land. I said, "You just described that as her making herself the victim. I want you to think very carefully about what a victim is. A victim is not someone who is inconvenient to you. A victim is not someone whose timeline you find unreasonable. A victim is someone who gave something in good faith and received nothing in return, not even the basic courtesy of a returned phone call." I looked at him steadily. I said, "Your mother sat in this chair and she told me this is a small amount. She told me she knows it looks strange. A mother suing her son. She apologized for being here, Mr. Holloway. She apologized for taking up the court's time over $200 that she lent you because you asked her to. I want you to sit with that for a moment. Your mother apologized for asking to be paid back." Kevin Holloway was not looking at the table anymore. He was looking at me. Something in his face had shifted. I could see it from the bench, the particular change that happens when something that has been exterior suddenly becomes interior, when a person stops defending himself long enough to actually hear what has been said. I said, "I am going to find in favor of the plaintiff, $200 plus filing costs, payable within 30 days. But I want to say something beyond the ruling." I looked at both of them. I said, "I have been on this bench for 40 years. In that time, I have seen families broken over millions of dollars and families broken over nothing at all. And I have learned that what breaks them is almost never the amount. What breaks them is the accumulation of small moments in which one person decides that their convenience matters more than the other person's dignity. $200 is not what this case is about. This case is about a woman who drove 40 minutes when her son called and a son who could not find 40 minutes in 4 months to make it right." I said, "You have a mother who still shows up for you. Not every person in this room can say that. Not every person in this courtroom today has someone who will drive 40 minutes in October when they call. I want you to understand what that is worth before you spend any more time describing it as dramatic." I sat back down. The courtroom was completely silent. Kevin Holloway sat at the defendant's table and he did not move for a long moment. His jaw was no longer set. The annoyance was gone. What was there instead was harder to name, something between shame and grief and the particular stillness of a person who has just understood something he cannot ununderstand. Frances Holloway sat with her hands still folded, and she looked at the front of the room. She did not look at her son. She did not need to. I struck the gavel and called a brief recess. When I came back out 10 minutes later, Kevin Holloway was standing beside his mother's chair. He was not saying anything that I could hear. He had his hand on her shoulder and she had her hand over his, and they were both looking at the table. I do not know what passed between them in that recess. It was not my business to know. What I know is that they left the courtroom together, side by side, Kevin carrying his mother's purse because she had both hands occupied with her coat, and that the woman at the plaintiff's table who had said she didn't have anywhere else to go walked out through those doors with somewhere to go. That was February 9th. I have thought about February 9th many times since, about what it costs a mother to file a claim against her own son. Not legally. Legally, it costs the filing fee and an uncomfortable mourning. I mean what it costs internally, over the weeks before she files, sitting with the phone in her hand after the 7th unanswered call, turning it over, arriving finally at the conclusion that she is out of other options, the specific quiet devastation of that arrival. I think about the apology. She apologized for being there. She said she knew how it looked. She knew this was not what courts were for. She knew it was a small amount. She offered the court 3 separate justifications for her own presence before I had asked for any of them. That is the behavior of a person who has been made to feel over a long period of time that needing something is an imposition, that asking is a burden, that requiring anything beyond the absolute minimum is a form of drama. She had driven 40 minutes in October because he called. She had asked 7 times over 4 months. She had filed here as a last resort, and when she arrived, she apologized for arriving. I have thought about Kevin Holloway, too. I do not think he is a bad person. I have seen bad people in this courtroom, and he was not that. What he was on February 9th was someone who had been moving through his life with a particular blind spot so long that he had stopped seeing it. The blind spot that forms when someone has always been there, when someone has always answered, when someone has always driven 40 minutes without being asked twice, and you begin, without meaning to, without even noticing, to build your life on the assumption that they always will be, that the calling and the showing up are simply a feature of the landscape, that the landscape does not require acknowledgement. He looked at his mother when I asked him to. I believe that something changed in him in that moment. I cannot know for certain. Courts do not have a way of measuring that, and I am careful about claiming more than I can see. But I saw his face when he looked at her, and I saw his hand on her shoulder in the recess, and I know what it looked like, and I choose to believe what it looked like. Frances Holloway deserved more than a hand on her shoulder 10 years into a pattern she should never have had to learn to live with. She deserved better than arriving at a courthouse to apologize for needing to be paid back. She deserved a son who called not only when his rent was short, but when the week had been long and he thought she might like to hear a voice. She may still get that. I hope she gets that. What she got from this court on February 9th was smaller and more limited but real. A ruling in her favor, a room that heard her, and a moment in which her son had to look at her face and understand what the last 4 months had looked like from where she was sitting. That is what courts can do. It is not everything. But on a Tuesday morning in February for Frances Holloway, it was what she needed. I have been on this bench for 40 years, and I have stood up perhaps 5 times. Each time has been a moment when the words alone were not enough, when the thing being said required the full weight of everything I have spent 4 decades building, and when sitting down was a way of withholding that weight from the person who needed it. Frances Holloway needed it. I stood up, and when I did, I felt 40 years of this work behind me. Every Frances I had not been fast enough to see clearly. Every moment I had stayed neutral when neutrality was its own kind of failure. Every case that looked small on paper and was enormous in the room. I felt all of that behind me, and I used it. If this story reached something in you today, if it made you think about someone you have been meaning to call back, something you have been meaning to return, something small that has been waiting long enough, do not wait for a courtroom. Do it today. Subscribe to this channel because there are 40 years of mornings like this one, and I am not finished telling them. And leave me a comment. Tell me about someone who always showed up when you called. Tell me their name. People like Frances Holloway have earned the right to be remembered.